Good evening and welcome to the regular meeting of the San Francisco Ethics Commission. We'll begin by taking the roll. Vice Chair Rennie.
Present.
Commissioner Hayon. Commissioner Andrews is excused. We are expecting Commissioner Keene momentarily. First item on the agenda are matters appearing, public comment on matters appearing or not appearing on the agenda.
Good evening, Chair Herr. Patrick Minot-Shaw, I'm here as a private citizen. I'd like to ask Mr. Chatfield to distribute these 5 copies to each of the commissioners, if you'd leave one for Commissioner Keene and Commissioner Andrews. I'd appreciate it. This is a formal complaint of a statement of incompatible activities violation by Sunshine Task Force member David Pilpel. It was submitted to the clerk of the Board of Supervisors this morning and to Mr. Chatfield, Mr. St. Croix. Mr. Pilpel has no business coming before you and holding himself out as an agent of the task force or an emissary from the task force during deliberations of Sunshine referrals sent to you for enforcement. I believe it's your responsibility, Chair Herr, that when Mr. Pilpel waltzes up to the microphone and introduces himself, David Pilpel, member of the Sunshine Task Force, and fails to mention that he's speaking in his role as a private citizen, I believe it's your responsibility, Chair Herr, to immediately cut him off and to rule him out of order. He is not permitted under the SIA to hold himself out as an agent of the task force. And if he's going to continue doing that, I think it's your responsibility to cut him off and not wait until 2 hours into a hearing, as you did on April 29th, or 28th, excuse me, when you waited until 2 hours and 8 minutes into the hearing to inform him no one is soliciting your input, Mr. Pilpel. Thank you.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I request that each member of this Ethics Commission review the recording for its May 28, 2014 meeting. When members of the public raised the issue regarding documents provided to the members of the Commission and yet not to the public, some of the comments made by the members of the Commission were completely inappropriate. The Sunshine Ordinance, which, like it or not, this Ethics Commission has an obligation to enforce, requires that such documents be provided to the public. How can we participate in a public meeting if you have documents that you are looking at and using, and we have absolutely no idea what those documents are, what they contained, and so forth? My personal concern about such documents is Mr. St. Croix using his position as executive director to manipulate hearings held before this commission. He determines in advance the desired outcome and then presents, quote, evidence, unquote, that will support the outcome and either marginalizes and or omits evidence that will support the outcome and that will support the change the outcome, and either it marginalizes or omits evidence that will not. The public has a right to see documents that you consider in open or closed session that are not specifically prohibited from disclosure. This ordinance has been in effect for more than a dozen years. You can't tell me that a person as experienced as the executive director doesn't know that documents that are for your consideration have to be provided to the public unless there's a specific exemption saying they do not. And yet we sat here that last meeting and had this ridiculous argument, and there were some disparaging comments saying to the public, well, what do you think we're trying to do, pull something over on you? The answer is yes, most of us do, and in particular the executive director. He decides what he wants the outcome to be, which is let the city employee off the hook and stick it to the complainant, who is usually a citizen of this city, and then he manipulates the session and he hides the documents from the public so that we can't look at them and tell what he's doing and have specific examples. Now, does he know that he's supposed to provide these documents? Sure he does. And he has an entire staff which gets millions of dollars a year in pay and benefits, etc., to handle these things properly. And the simple fact you can't follow a law that I can understand and I'm not getting paid for is ridiculous. You have an obligation to follow this law. And if you look at the executive director's report, what do you see on there on Sunshine? You see simply the number of cases. Every other item that's under your purview has a description of what you've done. That never has anything because you never do anything.
I want to address the description of Agenda Item 6. Of course, there are many public records that were left out of the group that was sent to you. This case started actually in October of 2012 when I made a records request. And it's gone through hearings, 3 hearings before the task force. It's gone through all the litigation in which Superior Court ruled that I was entitled to the record, and now we're in the Court of Appeals. So it's been about 1 year and 8 months, and that's 15 meetings of the Ethics Commission at which the very issue that is raised, vote on whether to assert the attorney-client privilege. Well, what have we been doing for 1 year and 8 months except dealing with that issue? And the question is, have you even seen the withheld documents? Because it's your privilege. It's not Mr. St. Croix's. The other point I'd like to make is that there's no really case pending right now. The Superior Court case is closed. The case now in the Court of Appeal has been argued, briefs filed, and all we're waiting for is a decision. So arguably it is pending, but there's nothing that you can do or I can do that's going to alter the progression of that lawsuit in the Court of Appeals. So that kind of surprises me. Defendant, there's no defendant. I was the petitioner, and the Commission and Mr. St. Croix were the respondents in the Superior Court. That case was concluded. The petitioner in the Court of Appeals is the Ethics Commission. There's no defendant. I'm the respondent. I am the respondent. So when you describe the Commission in some way as a defendant that's being beaten up by some person, in the city, I think it's a little sad. And finally, it baffles me what action you could actually take on agenda number 6. That's if you want to waive the privilege, you could do that. And I assume if you want to do some other things that would resolve it, that would also be something you could do. Thank you.
Good afternoon. Good evening, Commissioners. Can I have the overhead, please? My name is John Nolte. I'm here this evening to request that our staff that your staff accept mine and other candidates running for the November ballot form SFEC-142A for public financing. I've given an example of another department, how they do a checkoff list for every candidate. You do not. And so that is my problem, is that you are not functional. And that is the real issue here. When I applied for my candidacy with the Ethics Department and the file, I was given misinformation, and your department needs to do a complete checkoff list like this other department does of each candidate to come before the file to be more efficient. Please consider my request to accept my form SFEC-142A.
Sir, can you pass that up? We can't see it because of the overhead's not working.
Okay, well, this is just, I don't have to give you this personal information. This is a form from the Elections Department when I filed, and it's a checkoff list of everything that you're supposed to do.
And so what are you saying that the Ethics Commission didn't do?
I'm saying the Ethics Department doesn't do anything like that.
You can use the microphone.
Okay. I'm trying to explain that you're a dysfunctional department. You don't have any checkoff list like that for all the items you have to do with the Ethics Department when you file. If I had done that, I wouldn't be here.
And is it because you've been told you have to fill out certain forms that you have not yet filled out?
No, because not only that, they didn't even tell me about the forms. Yes. So if you had a checkoff list.
Are you now aware of the forms that you need to fill out?
Yes.
Okay. Thank you.
But it's after the due date. And so that's the problem I have, is that you have a complete checkoff list. That's another department that's more functional and gives that to the candidate when they apply. So I'm asking not just for me, but also the other candidates that fall in the same category.
Thank you.
Good evening, Commissioners and Mr. St. Croix. My name is Hope Johnson. I'm the former chair of the Sunshine Ordinance Task Force, and I'm here to speak on item number 6. Even though it was held over from last time, it's way at the end of the agenda, and it comes behind another potentially closed session, so I might not be able to stay the full time. So since it was held over, it would be nice if it was in front of some of the other newer items. But I would like to encourage you to hear this item in open session. It is about public policy surrounding the Sunshine Ordinance and its connection, its specification that things related to the Sunshine Ordinance are not falling under the traditional attorney-client privilege, or they're exempt from that. And that's something that the public really needs to hear, especially in a time when right now government is trying to be as private and secretive as possible while making the public have to disclose everything, even without us giving our permission. So if you could please consider having this in open session, we would greatly appreciate it, because when I was on the task force for 2 years, we were pretty much shut out from whatever the Ethics Commission was doing along the lines of deliberating how they were going to handle sunshine complaints. And that is something that the public should know, how the Ethics Commission intends to handle it. And it's also in the Sunshine Ordinance that the city attorney and the deputy city attorneys cannot help departments withhold documents. And we need to find a way to make sure that that's not happening. Then the other thing that I wanted to just bring to your attention, that in the documents that you did receive, I know that you received a lot of the appellate documents, but it doesn't appear that you received the order from the Superior Court that grants Mr. Grossman the right to review the documents. And I think that that's probably something that would have been useful not only for the commissioners but also for the public. Thank you.
Good evening, Chair and Commissioners. I'm Gilbert Criswell of New District 8, And I just wanted to make a comment. How come I don't understand why your names all are not on here to list? I think that should be important to have all the commissioners' names on there. And I'm speaking about public financing for this coming election in November for the supervisor races. And, you know, I ran in 2000. I don't know if they had public financing back then, but I didn't make that kind of money where I got public financing. I don't think they had public financing in 2000. But I'm hearing from different candidates that they're having problems with the Ethics Commission with the calendar of when they are supposed to do their reporting and whatnot. And I think that would be helpful for the candidates to have that. I'm not running any treasury or candidates' campaigns. But when I ran back then, the Ethics Commission had a calendar of dates, so you could be your own treasurer, and you could turn in the filings accordingly. But from what I understand, there's been some problems with candidates not getting the public financing, and if the public financing is there and they meet the requirements, the city should definitely back up the candidates, even though they're not the incumbent of that district. Maybe they're an unknown candidate, but that's what public financing is there for. Thank you.
I guess this one too, since the overheads. My name is, my name is Michael Nolte, and dear commissioners and executive director, that's since no overhead. My name is Michael Nolte. I'm here today to talk about the procedures of forming the candidates about the Form 142A. Which is on the attachment here of what I just submitted. And on May the 27th, I went to the department to ask for all the documents to file as a candidate for the November 4th election. I received a handful of pamphlets and several stapled forms to be filed. I filled out all the initial documents and established an online filing. I then asked if there were any other requirements, and the answer was update my filings when I have a treasurer, a bank account, and an FPCC number. Another candidate on June the 12th informed me that, not the elections part, but another candidate informed me that there was a problem. He was having problems with the 142A public financing deadline, and wanted to know if I knew something about that. And I said no. And then I went to the elections department on June the 13th to request a Form 142A and try filling it out, but the clerk would not accept my form. I went to your staff on June the 13th, the 17th, and the 19th, 3 different times to try to file the forms. Each time I was told I could not. Your staff tells me that I cannot accept the form, my form after June the 10th, but they fail to acknowledge what procedures to take. And again, the form is a neutral form. It says whether I want to or do not want to have public financing. So therefore, I should have been handed it to me with all the other documents when I initially was at the office. I will be attending the trainings on June the 26th. I probably would be finding out this information then, and it would have been too late again to file on June the 10th. So that's why I'm here today. And again, my name is Michael Nolte, and I'm running for supervisor in District 6. Thank you.
Next item on the agenda, discussion regarding legislation passed by the Board of Supervisors on June 17th, which amends the city's lobbyist ordinance. St. Croix, do you want to introduce this matter, or Mr. Minardi?
Yep. Good evening, Commissioners. Jesse Minardi, Deputy Executive Director. The last meeting, the Commission requested that we have an opportunity to discuss pending amendments to the city's lobbying ordinance. Those amendments were passed by the Board of Supervisors last week, and we provided you with a memorandum briefly outlining sort of the main provisions of that ordinance that was passed last week. Start by saying that the most significant change that was made with these amendments was a change to the qualification threshold to qualify as a registered lobbyist. The current threshold is you have to have one lobbying contact, and you have to earn $3,000 over the course of a 3-month period for lobbyist services. In an effort to establish a more bright line test, because that threshold, the current threshold has been difficult both to understand by the regulated community, but also to enforce by staff. The Board of Supervisors established a one contact test if you are lobbying on behalf of a client, and then a 5 contact or more test within a calendar month if you're lobbying on behalf of an employer, say Director of Governmental Affairs, somebody like that. So this was sort of the main change, and again, the effort is really to make the rules easier to understand and easier to enforce. So there are a number of other sort of changes that were made that are laid out in the memo and that we provided to you, including requiring reporting by so-called permit expediters, folks that work down at DBI that help folks to get permits for various construction projects. Quarterly reporting, so they're reporting not exactly the same as lobbyists, but similar information. And then disclosures by developers of major city projects, disclosures with respect to donations of $5,000 or more to nonprofits that in turn have lobbied or may lobby on behalf of that developer's project. These are the main provisions. I'm happy to go through the rest of the memo if you'd like, or I can answer questions. We also have the benefit of Deputy City Attorney Josh White, who worked on the ordinance as well. So between the two of us, I think we can answer your questions.
Commissioners, any questions?
Well, assuming the mayor signs the ordinance, how are we intended to educate the community as to what the changes are and how they are to respond to them?
Sure. Commissioner Ray. Well, there are a couple of answers to that. First, we do have we're drafting regulations to implement the new changes, and those we hope are going to be before you at the end of July for your July meeting. And then the hope is with passage of those regulations, we are going to update the lobbyist manual that we have that we're then going to be able to distribute to registered lobbyists. And then we're going to update our online lobbyist training that under the new rules, all lobbyists will be required to take that training. They're required now, but they're going to have to file a statement certifying that they did it within 1 year.
But as I understand it, under these regulations, if Joe Blow, private citizen, goes to his supervisor and urges him in support of some legislation, is he a lobbyist?
No, he would have to be compensated for that contact, yeah, on behalf.
But the level of compensation is no longer relevant.
Right, that's correct, yeah.
Can you talk about what costs are going to be imposed on the commission in enforcing the ordinance?
Well, in terms of administering, really, probably the main costs, we do anticipate, based on some feedback from the regulated community, that the number of lobbyists will increase by virtue of the new threshold. That, of course, will take staff time in dealing with, getting people signed up, problems, issues that come up. There will be the fees that are collected with the lobbyists as well, but there obviously will be additional staff time. And then there is the issue of, for the permit expediters, that reporting requirement goes into effect January 1 of 2015, and getting that online will obviously be a cost because we have to amend our contract with NetFile, et cetera.
What about the cost of the audit?
Well, yeah, that's correct. Well, right now the requirement is for one audit a year, and there obviously will be staff time that'll have to be dedicated to, quite frankly, getting up to speed on the lobbying requirements. But then there'll also be, obviously, this. We don't know how many we're going to audit immediately, particularly for the first year, but that will obviously be staff time as well.
So they're saying at least one. Obviously, we're hoping to do more, I would think.
That's right. That's right.
And the idea is what? That will. How will we determine how many is feasible?
Well, I think we'll look at the number of registered lobbyists, number one, that are out there, which I don't know off the top of my head right now. Again, we think will probably increase. We're also going to look at our capacity and our workload. We're trying to get through the number of audits we have for the campaign finance right now. We're optimistic we're going to get through a lot of them by the end of this year. So a lot of it will be that balance of making sure that we're looking at enough, but also taking into account our staffing and our workload.
Other questions? Okay. Public comment?
Commissioners, Ray Hart, Inspector, San Francisco Open Government. First, I'd like to say that the conversation so far has me disturbed in the fact that you seem to be treating this as a fait accompli. It's, they're going to change their law and you have to implement it and do it the way they say, and you have no ability to do anything other than simply do that. You have a moral obligation to look at these laws and see if the changes are appropriate, and also to raise any issues that might come up as far as the implementation of the law, which is your responsibility. And simply accepting it and saying, well, whatever they do, we're just going to teach people to do it, is unacceptable. I will be following very carefully the discussion regarding this agenda item and any subsequent action that might be recommended or taken. 3 examples. In Section 1, as long as contacts with elected officials are through an in-house lobbyist, contacts can exceed 48 per year without triggering a threshold. So if I have interest in the city and I have somebody who works for me and I send them every week to talk to somebody, I don't have to report them as a lobbyist. And how many thousands of lobbyists do we have? And if they all follow that rule, we could have 50,000 visits a year, none of which would be recorded. It would look like the lobbyists just were gone. In Section 3, adding an exemption for nonprofit organizations is wholly unacceptable. These groups receive millions of dollars per year as a result of their contacts with city officials. Such contacts must remain subject to public scrutiny. I've raised the issue of the Friends, and that has been such a devious and hidden operation. The last time they snuck it in and held it at a secret meeting that wasn't even on the agenda, so that none of us that objected to the Friends and their financial chicanery would know to show up. In Section 4, random audits of at least one lobbyist per year. What a joke. Even saying, oh, well, we'll probably do some more is a joke. There ought to be some sort of a reasonable minimum like 20 or 25 so that the public would have some assurance that it is not simply up to your pull it out of the air as to how many of these you're going to do. The Chu legislation, as it's described, is nothing but an effort by David Chu to hide some of the 597 contacts with lobbyists documented by him by Supervisor Campos' campaign. The Board of Supervisors will pass these amendments to hide the overwhelming impact lobbyists have on our city officials, particularly on the members of the Board of Supervisors. Lobbyists run this city, and I've said it before. You don't approach the Board of Supervisors unless you got a check in your hand votes in your pocket, or a lawyer at your side. Average citizens, the 99% of us, haven't got a goddamn chance.
Patrick Minot-Shaw is a private citizen. I would counter Mr. Hertz that you don't have a moral imperative. You have an ethical one. But I get it that you guys have problems with ethical issues. One audit, what size of a needle in a haystack is that? I was glad to hear Commissioner Rennie raise the same concern that I had over whether a private citizen sending a single email to the 11 Board of Supervisors would constitute a lobbying violation, because you're going down a really slippery slope opening up that door. For instance, if I were to send all 11 supervisors a single email on a Tuesday complaining that the Ethics Commission executive director had withheld from you the entire case in Mr. Grossman's lawsuit, and you only got the appellate portion, would I be accused of being a lobbyist for reporting you guys as having only considered part of the court case? What about if on the next day I sent a different email to all 11 supervisors, say over bicyclists on the sidewalk in my neighborhood? Would that be considered lobbying, when actually I'm just writing about my pedestrian safety? You need to urge the mayor to send that legislation back to Supervisor Chu and make darn sure that it's very clear that the 5 contact limitation will not apply to private citizens, Commissioner Rennie. Because when I first looked at it, that was my immediate concern. Now, I haven't seen any of the amendments that were tweaked, but that needs to be crystal clear. Citizens have every right to petition their government and not be misconstrued as lobbyists.
Good evening, Commissioners. Anita Mayo, Pillsbury, Winthrop, Shaw, Pittman. The only comment I wanted to make is that it's very important that the Commission reach out to all lobbyists and potential lobbyists and developers, given the fact that this legislation does change the thresholds for qualification as a lobbyist. The legislation imposes joint and several liability, and that can be imposed on the lobbyist employer when the lobbyist violates the ordinance. And then the developer disclosures, which is something that is totally new, that requires the developers to have to report their donations of $5,000 or more that they've made to nonprofits if persons from those nonprofits have lobbied the city regarding the developers' projects, and late filing penalties can be imposed for failure to file the reports. So again, it's just very, very important that the Commission reach out, and I think that's what they want to do, but they reach out to everyone regarding the changes. Thank you.
Thank you. The next item on the agenda is discussion and possible action regarding proposed stipulation, decision, and order in connection with the complaint initiated or received by the Ethics Commission.
So I want to make an announcement that we're going to try to do a special procedure with the 3 closed session items that I think will work for the convenience of everyone here and the SGTV people. We plan to have public comment on item 4, and then a vote on whether to go into closed session, and then we will have a second public comment on item 5 and have a vote on whether to go into closed session, and then have public comment on item 6 and a vote whether to go into closed session, and then we will have one long closed session with all 3 discussions, so that we don't have folks having to go out in the hallway for one closed session, come back in, go back out in the hallway a second time, come back in, and go back out in the hallway a third time.
Assuming we agree to go into closed session.
Correct. So the first item would
Mr.
be...
White, any problem with that you can think of?
No, as long as you said, there's agreement to go into closed session as to each item.
So the first item would be public comment on specifically on item 4, including whether to meet in closed session.
Any public comment on item 4?
Commissioners, Ray Hartz, Director, San Francisco Open Government. Agenda items, especially relating to closed session. Sunshine Ordinance Section 67.7b reads as follows, quote, "A description is meaningful if it is sufficiently clear and specific to alert a person of average intelligence and education whose interests are affected by the item that he or she may have a reason to attend the meeting or seek more information on the item," end quote. How would anyone know if their interests are affected by this description? All it says is something legal. End of story. And if you go back and look at the ordinance, it specifically says that there are certain reasons you cannot place information about what specifically the item is, only things related to whether or not it might allow somebody to flee the district and some other things. It says nothing more than a discussion of anticipated legislation, telling the public some information, such as the specific case to be discussed, would not in any way breach confidentiality or compromise attorney-client privilege. It would, on the other hand, alert a person whose interests are affected by the item, which is a requirement of the law. I sincerely hope this Commission will not attempt to dismiss out of hand, as it did last month, the public's very real concern that matters be considered in full view of the public. That includes agendizing things properly. I'll say it again. Mr. St. Croix has been the executive director as long as the Sunshine Ordinance has been in place. He knows what the requirements of the law, and yet he puts these generic, meaningless agenda descriptions so that nobody would have any idea what the hell it is you're talking about. You could be discussing a case related to something that was referred from the Sunshine Task Force related to a matter from me, and I wouldn't know whether to come to this meeting or not. And neither would anybody else. If you can't put a goddamn agenda item on there that a person of reasonable intelligence can look at it and tell whether, have some idea of what it's about, then it's not properly agendized. And you can dismiss it, you can poo-poo it, you can do whatever you want, but the bottom line is your obligation is to enforce the Sunshine Ordinance. And you're not doing it. In fact, you're violating it by putting these generic descriptions which don't tell anybody anything. And then when we come here and raise the issue, you treat it like it's a damn joke. It's not. Very frankly, I'm getting a little sick and tired of having to come here and point out the fact that you can't seem, with the millions of dollars of staff time and effort you have, to even follow the basic points of the law, let alone its intention. The intention is these things be done in public, and the intention is that we need to have some information to know what it is you're going to be discussing to make intelligent public comment.
Patrick Minette-Shaw. I'll combine my public comment for items 4 and 5. I see that Agenda Item 6 actually lists the name of the court case in Mr. Grossman's case, but 4 and 5 just say anticipated litigation as plaintiffs. It would be helpful to members of the public if you would broaden these descriptions so that people of ordinary intelligence can figure out what part of Charter Section C3699-13 you're referring to, and what type of case you are considering entering into anticipated litigation. The public has a right to know what it is that you're considering.
Is there a motion?
Sorry to get up here so late, but I've been parsing the Brown Act, and I don't think the description is accurate in at least one respect. Anticipated litigation actually is covered separately in both the Sunshine Ordinance and in the Brown Act. And the Brown Act says that, let's see, specify by existing litigation, anticipated litigation, okay. In addition to the information noticed above, the agency may be required to provide additional information on the agenda or an oral statement prior to the closed session pursuant to certain paragraphs of the law. But there's an earlier provision that deals with the fact that you have to demonstrate that providing that type of information, namely the name of the possible litigant and so forth, you have to justify it by showing that there would be prejudice to either service or process or to your case. And I don't think that's been done here. I can't put my finger right on it, but I know it's in here. And I'm sure with your high-priced lawyers, you'll be able to check with them. Thank you.
Is there a motion to move into closed session? And before we do that, does the city attorney or the staff have anything to say about whether or not it's appropriate to go into closed session for an agenda item like number 4?
I would say that it's mandatory as to item 4 and 5. I think that under charter, with respect to item 4, there's the charter section C 3.699-13A. If you look at the final paragraph, it basically states that any member or employee of the commission who discloses information about any preliminary investigation prior to a probable cause determination shall be deemed to have committed official misconduct. So I think if the commission did not go into closed session and had a conversation about the proposed settlement, that would be a violation of that provision of the charter. Similarly, with respect to item 5, under that provision as well as the commission's own regulations, probable cause hearings have to be held in closed session. So I don't think that there's discretion on that issue. Similar to what we discussed at the last meeting, it's strange to have to vote to go into closed session, even though there's really no latitude. But it is what it is. As to item 6, I think that there may be some discretion. I think the commission has discretion over whether to go into closed session, but this truly is pending litigation, and I think it would be impossible to provide full and frank advice to the commission about that pending litigation in open session.
Is there a motion to go into closed session?
Before we get to motion, and I think at our last meeting, we said before we go into closed session, we're going to explain why. And I think you should understand that when we are considering whether or not a complaint should be filed against an individual, the individual has been informed. He or she knows that we intend to discuss that matter. And if after in our closed session we determine that no complaint should be filed, she or he has a right to the privacy, because it's like any kind of a legal process. The government and the district attorney, when it initiates an investigation, doesn't go to the public and say, hey, we're looking into Mr. X to see whether he or she has committed some crime. That's an invasion of their privacy. The only purpose that we're doing this in private is if we decide that, yes, there's probable cause, it then gets disclosed. and there will be a public hearing. But this is sort of the first step in the process. It's not trying to keep the public out. It's trying to protect the interests of the individual who's been notified that there's going to be this determination, and he and she can come in and say, hey, there shouldn't be a probable cause determination. It's nothing to do with protecting or keeping something secret from the public, that the public has a right to know until we act. I would move we go into closed session.
All in favor? Aye. Opposed? Hearing none, that motion passes. So for number 4, we will go into closed session. Public comment with respect to item number 5, discussion and possible action regarding probable cause determinations in connection with complaints received or initiated by the Ethics Commission.
Commissioners, Ray Hartz, Director, San Francisco Open Government. First thing I'll do is respond to Commissioner Rennie's comments, which are totally disingenuous and frankly dishonest. Saying in public that these people all know what's going on and that there is a hearing is a bunch of crap, because in March you had a hearing. I was never notified prior to leaving the state, and you had the hearing the day before I got back into the state. So if you want to say that yeah, there's this imaginary thing out there that all the people who are involved in this know, then that's not the case. And add to that the fact that it may be not my particular case that's up, but it may be a case about which I, as a member of the public or as a party to the case, may be involved. And I should know exactly, have some idea as to which cases these are. This particular item, here we have the same issue, only in triplicate. We have 3 cases about which no one has any idea, apparently including the members of this commission, regarding what cases will be discussed. Of course, I'm assuming that since no documents whatsoever were produced or provided for the public, that the commissioners received nothing in advance. That's the same issue we talked about last week with Mr. Goldman's case. What the public is asked to believe is you're going to discuss 3 cases without any advance consideration or preparation. They didn't send you any documents, didn't tell you what the cases were, didn't have a chance to think it out. You know nothing, because if you do know something, we're supposed to know anything that you know that isn't privileged. You don't know what the cases are, don't know the scope of the discussion. Damn, you don't have any idea at all. Or at least that's the way it seems from the public's point of view. If that is the case, you actually can have no idea whether to go into closed session or not. If you don't know what you're going to discuss in closed session, how can you rationally decide that a closed session is required? And if you look at this agenda item, we can't tell whether a closed session is required because we have no idea what the hell it is you're considering. Sunshine Ordinance Section 67.8 states that the agenda disclosure shall, quote, specifically identify a case under discussion, end quote. That's what the law says. And you can be as disingenuous about it as you want and say, well, we don't have to tell you anything except it's a legal case, and that's bullshit. The law says you have to say what the specific case is. If you don't understand that, then your annual signing of the Sunshine Declaration, you're falsifying it. Go read the damn law instead of pulling it out of your backsides.
Patrick Manetsaw. It appears you may have a short memory. Just a month ago, DCA White advised Commissioner Keene that because the agenda and meeting materials had been deficient, you had to postpone Mr. Grossman's case for a month until today. Mr. Grossman has just informed you that your agenda more than likely violates the Brown Act. It would be useful to hear DCA White weigh in on whether both items 4 and 5 should be delayed another 30 days until you get into compliance with your agenda requirements. You do remember what happened 30 days ago. when item 6 was postponed for a month, right?
The agenda item really is confusing. It's in connection with a complaint initiated or received by the Ethics Commission. So it's one or the other, right? Of course, the public isn't entitled to know which it is. Then it refers to conference with legal counsel, anticipated litigation as plaintiff. Okay? So if you receive the complaint, you would be suing, but if you initiated the complaint, you would still be suing. Okay, I suppose that's the way it works. And then you talk about the Brown Act, and I think I found the section I was looking for. If the session is closed, I'm reading now from, it's a long one, 54956.9, which I think is referred to in the agenda. It says, based on existing facts and circumstances alleged, it says you can go into closed session with your attorney and have the session subject to the attorney-client privilege. Based on existing facts, the legislative body of the local agency has decided to initiate or is deciding whether to initiate litigation. And then it says, if the session is closed pursuant to subdivision A, the body shall state the title or otherwise specifically identify the litigation to be discussed, unless the body states that to do so would jeopardize the agency's or that, agency's ability to effectuate service of process upon one or more parties, or jeopardize its ability to conclude existing settlement negotiations. Well, you're talking about settlement in the agenda item. I thought. Oh, stipulation, I'm sorry. Anyway, I think the point is being made. Thank you.
Commissioners, any comments or questions? Is there a motion to go into closed session with respect to agenda item 5?
So moved. I'll second.
All in favor? Aye. Opposed? Hearing none. That motion passes. Agenda item number 6, discussion regarding the status and background of pending litigation as defendant, Grossman versus St. Croix and the San Francisco Ethics Commission. Public comment.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I've been waiting with keen anticipation for the result of the discussion whether to handle this agenda item in full view of the public. Hell, I'm curious as to whether you'll let the public have any opportunity to observe your discussion. I'm going to go out on a limb, and I wrote this 2 days ago. Her, Rennie, and Hayon will vote to hide, and Keene and Andrews will vote to let the sunshine in. I'm prescient. I win either way. Either I'm right and you choose to hide, which proves your bona fides, or I'm wrong and you choose to be open, which is my desired outcome. I doubt I will be wrong, that is, but I sincerely hope I'm wrong. John St. Croix, the executive director's pattern of hiding as much as possible is getting truly tiring. Not placing items properly on the agenda, not providing the supporting documentation, et cetera, et cetera, et cetera. It doesn't seem that Mr. Croix, St. Croix feels any obligation to follow any aspect of the law. And it's blatant. And we come back month after month and case after case and issue after issue, and you just sit up there and look like a bunch of see no evil, hear no evil, speak no evil monkeys. I believe the members of this Ethics Commission need to give the Executive Director clear instructions to be as open as possible. Now, I don't think you're going to do that because I think you like the fact that he keeps everything hidden. So you can go back and do whatever you want. And this constant refrain of we're not trying to hide anything, it's not you're not trying to hide anything, you're hiding everything. It's rather stupid to sit up there and say, we're not trying to hide something. No, you're not trying to hide something. You're successfully hiding stuff. You won't even tell us what these 3 cases are about. Or 4 cases if you want to complete the first 2. And the only reason you did Mr. Grossman's, I think, is because you know Mr. Grossman would call you on it. You hide and hide and hide. And if there's any member of the public who doesn't think that's the truth, then they should come here and participate in these meetings. You notice that many people don't bother to come here. That's because they know you're a bunch of politicians appointed by the same politicians you're supposed to hold in check or hold accountable. And what have you ever done? I will raise this question once more. I would like one of you at one of these meetings to get up and honestly tell me how any damn thing you've done has improved the ethics of this city. You confuse activity with accomplishment. You do dozens of things and accomplish nothing.
Patrick Minutsaw. So we were here 30 days ago, and your memories really slipped by. We notified you 30 days ago that you are not the defendant in this case, but your agenda continues to assert that you are. You're the plaintiff in this case, which I'm sure even Commissioner Hayon, living in the Richmond, understands the difference between plaintiffs and defendants. Commissioner Keene last month wanted to quickly move to ignore Deputy City Attorney White's advice to postpone it for a month. Keene, according to the audio, wanted to jump right into an open session right there on the spot, I believe. And it struck me then, and it strikes me now, that to the extent Commissioner Keene elected to attempt to ignore Deputy City Attorney Josh White's city attorney advice, sounded just like appointments to the Sunshine Task Force, where Supervisor Tang is using a litmus test of undying loyalty to city attorney advice. So if Keene can ignore White's advice, why can't the Sunshine Ordinance Task Force, who after all had reached simply a different interpretation of the city attorney advice, as many city policy bodies often do during open session, they find ways to get around the advice just presented to them by deputy city attorneys. But what happened to Keene's idea of government transparency and holding a closed session and an open session, particularly on a case that is not really pending litigation anymore? All that needs to happen is for the appellate court is to release its opinion. Litigating is done. It's not pending litigation anymore. And you should hold this session in open session so that we can hear what kind of belated advice you're going to get, since you took no action to authorize Mr. St. Croix to file this case in the Superior Court. He did that without your explicit permission.
I want to read you something from the Brown Act, Section 54-956.9. But before I do, I want to mention that after the last meeting, I put in a records request to Mr. St. Croix for copies of the material that was provided to the commissioners before the last meeting. I got copies, I think, of just about everything that's listed here, but one was withheld because it was subject to the attorney-client privilege, asserting the attorney-client privilege on a material that was provided to the commissioners before the meeting. This is what 54956.9 says in part. For purposes of this chapter, all expressions of the lawyer-client privilege, other than those provided in this section, are hereby abrogated. This section is the exclusive expression of the lawyer-client privilege for purposes of conducting closed session meetings pursuant to this chapter. And what it says is that anything that you get before the closed session meeting is a public record, fully disclosable. And if your lawyers don't agree with me, I'm more than happy to have that debate with them and see what we get out of it. So let's suppose there is a decision from the Court of Appeal and you win. It's going to go to the Supreme Court. I think you should ask your lawyers what your chances are, just as I would ask mine what my chances are. But if you think about all of the work that's been done, all the money that's been spent by me and by you, representing the taxpayers so far, and this is the first meeting, you're ready to talk about this case, this is going to be huge in cost, whether I win or you win. And I think you should keep that in mind. The last thing I think is really important, and it's about time you came to grips with it, is that your bylaws say you will comply with the Sunshine Ordinance. What happened to that compliance? What is it going to do to the way you conduct your business when it comes to these referrals from the task force? You're going to overturn them every time the respondent relied on, or the complainant relied on, the now illegal provision in the Sunshine Ordinance? I don't think so. You should think about it, and hard.
Good evening again, Hope Johnson. I just want to urge you again to please hold this in open session. We've gone on for many years. I mean, this has been going on for longer than that, but 4 years that I've been involved, about the policy surrounding the Ethics Commission handling sunshine complaints. And when I was on the task force, the Board of Supervisors have now accused us of violating the charter. But this particular commission passed memos that said that our referrals from the Sunshine Ordinance Task Force were not valid, that our findings were not valid, even though none of you heard it. It was never heard or voted on by even one commissioner. So let alone the charter, none of them. So Mr. St. Croix would write them, and the deputy city's attorneys would vet them, and then if nobody commented on them, they were never heard in public. They were never voted on by the Ethics Commission itself. So the staff was passing these, and it happened for years. And I appreciate that the commissioners did a lot of work to try to bring that around, to change it so that there was an open meeting about these sunshine complaints. And I know you've worked hard on it, but it is public policy. And the Sunshine Ordinance is in the administrative code. It's black letter law. But it was also voted on by the voters. And they had the opportunity to see that it's just one small section of the attorney-client privilege that they're dealing with. And it's dealing, and the city attorney's office represents the people too. These departments belong to the people. And we don't want the city attorney's office to be able to tell the departments how to avoid giving records to the public, because the records are presumed disclosable. And it is the responsibility of the people who think that they should not be disclosed to show that they fall under an exemption. That's a state law, not just the Sunshine Ordinance. So this is a public policy discussion that needs to be an open session. People need to be able to go back and refer to it. The general public shouldn't have to rely on what the commissioners say about it. We should be able to hear what is going on. And it's frustrating for us to say this over and over again. It's been going on for years. I had to hear it for 2 years at 5- and 6-hour meetings because there was no openness about how the Sunshine Ordinance Task Force referrals were handled when it came to enforcement. And it went on, and it continues to go on. And the only way to solve it is for people to see how you're deliberating it. Thanks.
So I think there are 3 possible things we can do, but I welcome the views of my fellow commissioners and the city attorney and staff. I think one option is to receive from Mr. Minardi or Mr. St. Croix an background on the case, what's been happening, what's been going on, no attorney advice. I think the second option is to do that in open session and then go into closed session where we can solicit advice from the city attorney. The third option would be to just go into closed session, I think, and solicit the advice of the city attorney. Thoughts from the staff or my fellow commissioners?
Sounds right to me.
City attorney?
I think those all sound like options you could consider. I think those are all options that you can consider.
Well, I suppose there's another option, and that is that we just simply have a public hearing, not limited as you sort of limited the public portion of it.
I suppose there is an option where we could waive the attorney-client privilege and have the advice in open session. I would strongly oppose waiving the attorney-client privilege in a matter that is currently at issue. Oppose. I would oppose.
I'm with Commissioner Rennie. I mean, we've talked about this long enough, and everybody seems to want, including the principals in this, to have an open hearing. Let's have an open hearing. Now, as to the attorney-client privilege with legal advice, I'm prepared to take your advice, Commissioner Herr. That's not something that I feel qualified to say one way or the other.
Excuse me, I am deaf since birth, Commissioner. I would really appreciate you using the mic.
Okay, so maybe I'll ask it this way. Is there a motion to receive from the staff an status update on the case in open session, but then to move into closed session for any attorney-client privileged advice that we seek from the city attorney? Commissioner Han, are you?
Yeah, I would second that, or I would agree to that.
Is there a motion to do so?
No, so moved.
Is there a second?
I'll second it.
All in favor?
Aye.
Aye. Should we?
We just had public
I think they just had public. I think you had public comment on the issue of whether to go into closed session, so I don't think it's necessary to have a second round of public comment.
Okay, the city attorney has advised that we don't need to go into have public comment because we just had public comment on this item.
It says on every motion. That was the motion before we had a discussion of the agenda.
Including whether to meet in closed session.
Did we vote? Did we just vote? Okay.
We did.
Okay. We are going to go into.
Why don't we do the
You want to do the
public
open session?
discussion so these folks don't have to wait until we do all the other stuff?
Okay, would the public prefer that we do so? Okay, let's do the public session on item number 6. Mr. Minardi or Mr. St. Croix, do you want to give us some background and status on the matter that's currently pending?
This case went to the Court of Appeal earlier this year. There was a certain amount of time when briefs were submitted by both parties back and forth. Oral arguments were heard on May 1st, and a decision is due by the first week in August. The basis for this agenda item was at some point Commissioner Kane requested from me the briefs filed pertaining to the appeal. I offered him all the rest of the documents related to the case. He did not want them. And then he requested that we calendar a discussion on those briefs that he asked for and that I sent him. Those are the briefs that you received as part of the agenda packet for this meeting. I'm not entirely sure what specifically he wanted to discuss. He didn't provide any guidelines or anything, but wanted to have a general discussion about that. After the Court of Appeal releases its decision, as Mr. Grossman alluded to, there is a certain amount of time for the party that does not win the case to file a motion with the state Supreme Court. So it could be that this case it remains pending for a number of months to come.
Questions from the commissioners regarding the status or background of the case? I have a question about what the Superior Court judge did. Did he review in camera the underlying documents?
No.
Was it stipulated that the documents were attorney-client privilege and the issue was whether the Sunshine Ordinance allowed disclosure of attorney-client privilege in work product documents?
It was not stipulated. There was an assertion of the privilege. Well, do you want me to? There was an assertion of the privilege, and then the question was whether the provision of the Sunshine Ordinance is valid in light of the city charter.
So did the judge find that because it doesn't matter, in his view, the ordinance allowed for disclosure regardless of whether they were privileged, that he didn't reach the issue of whether the documents were in fact privileged?
Right. That's right. The judge did not address the issue of whether the provision of the Sunshine Ordinance is valid or invalid in light of the charter. Both parties agreed that that issue was before the judge, but the judge...
No, that's not my question. My question is, did he determine that he didn't need to review the documents in camera because it didn't matter whether the documents were privileged or not? Under the ordinance, they would still have to be disclosed.
Oh, that's right.
Okay. Any other questions?
Now, as I understand it, that everything that was presented to us prior to the May 28th hearing and again packaged to us here, that everything was produced or made available for the public with the exception of one document, And I assume that one document is the document prepared by the city attorney's office?
That's right.
And you're asserting that that was attorney-client?
The memorandum.
Is attorney-client?
Yes.
Work product.
Or work. Well, I mean, it's a communication as well as a work product, yes.
Anything else? Okay, so now I think we should go into closed session on items 4 through 6. And we will then notify the public of when we have completed our closed session.
You can do a public comment if you want to.
We should do public comment. Okay,
I think on agenda item 6, there could be public comment.
on agenda item 6 relating to
the Grossman
our
matter.
discussion that we just had.
Right. Because
Okay, let's have public comment on that then.
Well, I tell you, it's you guys are a real piece of work. I don't know whether to assume that that's the kind of idiotic discussion you have when you go in the back where none of you says anything except ask the city attorney a couple questions. Except you go in there for a half hour, 45 minutes, an hour. I have a hard time feeling that that's the type of discussion you have when you're in closed session. I'll say this right to your face. You're not honest people. And you can say over and over and over again how you want to be open and you want to be honest, but this is all about the fact that you don't want to disclose things to the public about how you handle Sunshine and Brown Act and other issues related to open government. And you don't even want anybody in the public to know what the city attorney is advising you to do or not to do. You know, very frankly, if you were honest people, you would say, we don't think that it is appropriate to have this or that done in this or that way because of this reason. But you don't. You go into a closed room where you can have a meeting, have a discussion, say anything you want, and then come out and tell the public, well, we decided and you have to live with it. Very frankly, I think that especially the two of you who are attorneys, if you had a client and was on this end of these proceedings, you'd be raised in hell. You'd be heading to Superior Court in flash of a, yeah, whatever. You know, very frankly, it is inane for you to sit here month after month, year after year, and say how you want to be open and honest, and then every single action belies that. You hide as much as you can. Frank Herbert, one of my favorite authors, says, you know, politics is the art of appearing open and honest while hiding as much as possible. And that's exactly what you do. You come in here and claim to be open and honest, and what in the hell are you open and honest about? We just had a discussion about Mr. St. Croix's case. You didn't say a damn thing, and that was conclusion. Why was this even on the agenda? You had nothing to discuss. You didn't discuss anything. Except for what you really want to discuss, which you're now going to go into closed session and probably discuss a whole bunch of other stuff. And last month when we were standing here and talking about this issue and you were all making these idiotic comments about, oh, you think we're trying to hide stuff. I know you're trying to hide stuff. I know you hide stuff. I know you have people like Mr. St. Croix who will take a case where I'm one of the parties and will schedule it after I leave the state and hear it before I come back. And I come here and erase it to you and you just ignore it.
Mr. Hartz, we've just told you that we're going to be asking advice from the city attorney on the matter. So, you know, we're not hiding it. We're telling you exactly what we're going to be talking about in the closed session.
And I'm supposed to believe that the conversation you have is something that you had to spend that last 20 minutes discussing whether or not we should go into closed session. If that was the extent of your discussion, why did you need to even discuss to go into closed session about any of it?
I really am. I mean, I'm in some ways impressed that you think there are all these nefarious things we could be talking about in closed session beyond advice of the city attorney. Okay. Mr. Minute Shaw.
Thank you, Commissioner Hurd. I think you all know my website, www.stoplhhdownsize.com. It's all one word. I have read every brief filed from Superior Court all the way up to just before oral arguments at the appellate level. Every time I would read a filing by the esteemed Dennis Ferreira's staff, I was appalled. In fact, I was so appalled I wrote a really long analysis on it entitled Something About Fairy Dust Coming Out of the City Attorney's Shop. You should read it, every word of what I wrote. Because Mr. Grossman's lawyer, Michael Eng, absolutely shredded Deputy City Attorney Andrew Shen's garbage. There's nothing in the city charter that protects attorney-client privilege. Not a peep. That was the root of Mr. Grossman's case. The Superior Court was right to order immediate release of those 24 documents withheld from Mr. Grossman. Should not have dragged on for 2 years before arriving at this hearing tonight, where you're going to go into closed session and discuss God only knows what, because we don't really believe what you're going to discuss in there. This commission has too long of a history giving us reasons not to believe you. Mr. Grossman should prevail on the merits of his case. And the appellate court should get over itself trying to hold attorney-client privilege immutable. It's not when it comes to a narrow area of law focused on public access. Mr. Grossman is not waging a battle to get at some kind of documents that would give him a roadmap to undercut the city. He's after public records. What part of that don't you get?
It somewhat baffles me what you think you're going to do in closed session, to be honest with you. You can't assert your attorney-client privilege because Mr. St. Croix did that a year and a half ago. And he has steadfastly continued to do that with the support of the city attorney. So you can't undo that, and you can't do a redo unless you have not seen the papers yet and look at them and say, you know, what's the big deal? There's nothing toxic in here. So let's just let this troublemaker have his records. Okay, that's one problem. Another problem is that the provision in the Brown Act, which requires that I see every record that was provided to the commission before this meeting on this item, if I had a guess, there was some attorney-client privilege material in it. If I'm wrong, then hopefully what's in here is all that was provided you. But if I'm right, you have the same problem you had a month ago, which is the only place you can assert the attorney-client privilege is actually in the closed session. And there's a reason for that, because the public is entitled to everything that it can possibly see that you see except what's disclosed in the closed session. I really have a problem that, I've practiced law a long time, and I dealt with a lot of different kinds of people, but I simply do not understand condoning something that is costing the taxpayers of this city a ton of money. Last time, it cost $25,000. If I win this time, you can imagine what it's going to cost. And all because when I filed my request for the records, Mr. St. Croix could have said, we got to decide whether we're going to assert our attorney-client privilege. That was in October of 2012. October of 2012. And you know what's happened since then. I don't have to repeat it. Thank you.
Good evening again, Commissioners. Hope Johnson. The attorney-client privilege section of the Sunshine Ordinance, the section of the Sunshine Ordinance that addresses the attorney-client privilege that says that we're fighting over right now is not about an investigation. It's not about protecting some individual's right to privacy if there isn't something found. It's about turning over. It's about the Ethics Commission. This should be made clear. I mean, there's nobody here, but maybe somebody will watch this someday. It should be made clear that what you want to talk about in closed session is something that is related to how the Ethics Commission is going to enforce violations of the Sunshine Ordinance and the California Public Records Act. So the Sunshine Ordinance specifically says that those kinds of communications between the attorneys and the commissioners are not privileged. We don't want them to be privileged. The public doesn't want them to be privileged. And then the Superior Court judge agreed, as Commissioner Herr pointed out, without having to look at the documents. So in essence, if you go into this closed session and it's found again that the Superior Court's finding was correct, you're violating the Sunshine Ordinance by going into closed session. And this isn't about, I don't understand why advice from the city attorney about how to enforce sunshine complaints, even drafts, would be privileged. Why would the public not have access to those? It doesn't make any sense.
Ms. Johnson, at the risk of beating my head against the wall, I mean, this is sort of the way I see it. There's an argument that the documents that Mr. Grossman is seeking should be turned over, regardless of their privilege. I understand.
There's also a ruling.
I understand that point. I understand what the Superior Court did. The closed session we're talking about is to discuss pending litigation. And no matter what the court decides about the documents, it has nothing to do with whether or not the commission, because there's litigation and we are a litigant, can talk with our attorney about the litigation. Whether that litigation was about documents.
What pending litigation is it about?
It's the case that's been identified. So I just want to make it clear that there is a distinction
case that's identified
between the
over.
documents that are at issue.
It's on hold. That ruling stands. It's just stayed until the appeals decided.
And what we're doing right now, which relates to closed session.
So what you're saying is that it's pending litigation in case he has to file a Supreme Court ruling?
Thank you. Okay, let's go into closed session.
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television. SF Gov TV. San Francisco.
Okay, we are back in open session. We'll take the items that we discussed in order. First, item number 4.
On item number 4, the Ethics Commission announces that has reached a stipulation decision in order with Claudine Cheng, who has agreed to pay $9,000 for 3 violations of the San Francisco Campaign and Governmental Conduct Code. The stipulation will be posted on the Ethics Commission's website tomorrow.
Item number 5.
At its meeting of June 23, 2014, in the matter of Ethics Commission Complaint 18-121029, the Ethics Commission made a determination that there is probable cause to believe the following violations of the San Francisco Campaign and Governmental Conduct Code occurred and that the respondent, Robert Squeary, committed them. 1 violation of San Francisco Campaign and Governmental Conduct Code, Section 1.162, subsection A1, for failing to include a disclosure statement in the required type size on a door hanger. 2, 1 violation of San Francisco Campaign and Governmental Conduct Code, Section 1.162, subsection A1, for failing to include a disclosure statement in the required type size on a door hanger. Each commissioner who participated in a decision to find probable cause must certify on the record that he or she personally heard or read the testimony, reviewed the evidence, or otherwise reviewed the entire record of the proceedings. So each commissioner should so certify.
Vice Chair Rennie?
Here, heard the meeting. Yes.
So certify.
So certify, thanks.
Commissioner Han? So certify. And I so certify as well.
The respondent is presumed to be innocent unless and until such time that the allegations are proved in a subsequent hearing on the merits. The Executive Director shall issue an accusation in accordance with San Francisco Ethics Commission regulations for investigations and enforcement proceedings. At its regular meeting of June 23, 2014, on the matter of Ethics Complaint 18-131115, the Ethics Commission made a determination that there is probable cause to believe the following violations of the California Government Code as incorporated by the San Francisco Campaign and Governmental Conduct Code occurred, and the respondent, Melissa Apuya, committed them. 1 violation of California Code Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of January 31st, 2012. 2, one violation of California Government Conduct Code, Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of July 31st, 2012. 3, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of January 31st, 2013. 4, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of July 31st, 2013. And 5, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of January 31st, 2014. Each commissioner who participated in a decision to find probable cause must certify on the record that he or she personally heard or read the testimony, reviewed the evidence, or otherwise reviewed the entire record of the proceedings.
Commissioner, Vice Chair Rennie?
So certify.
Commissioner Han?
I so certify.
I so certify as well.
The respondent is presumed to be innocent unless and until such time that allegations are proved in a subsequent hearing on the merits. The executive director shall issue an accusation in accordance with the San Francisco Ethics Commission regulations for investigation and enforcement proceedings. Finally, at its regular commission of June 23, 2014, in the matter of Ethics Commission complaint number 2020-131115, the Ethics Commission made a determination that there is probable cause to believe the following violations of the California Government Code as incorporated by the San Francisco Campaign and Governmental Conduct Code occurred, and that the respondent, Wendy Aragon, committed them. 1, one violation of California Government Code, Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of July 31st, 2013. And 2, one violation of the California Government Code, Section 84200, subsection A, for failing to file a campaign statement Form 460 by the required deadline of January 31st, 2014. Each commissioner who participated in a decision to find probable cause must certify on the record that he or she personally heard or read the testimony, reviewed the evidence, or otherwise reviewed the entire record of the proceedings.
Commissioner or Vice Chair Rennie?
So certify.
Commissioner Han?
I so certify.
I also so certify.
Respondent is presumed to be innocent unless and until such time that the allegations are proved in a subsequent hearing on the merits. The executive director shall issue an accusation in accordance with the San Francisco Ethics Commission regulations for investigations and enforcement proceedings.
Agenda item number 6, the commission voted in closed session not to disclose its closed session deliberations. The commission sought the advice of the city attorney relating to the pending litigation. In addition, I did want to raise one thing. During the public comment prior to us moving into closed session, Hope Johnson was giving her public comment, during which I engaged in discussion with her. Subsequent, as we were moving into closed session, Ms. Johnson indicated to me that she had not completed her public comment and had time remaining, which the staff confirmed. We asked Ms. Johnson if she would like to return to give her public comment right there and then. We were going to go back into public session, but she declined. Ms. Johnson also expressed to me that she found my response to be rude, and for that I apologize to Ms. Johnson.
Okay, you need a motion on the closed session.
Is there a motion to not disclose the closed session deliberations relating to agenda item number 6?
Second.
All in favor?
Public comment.
Oh, public comment.
Commissioners, Ray Hart, Inspector, San Francisco Open Government, and I just don't ever understand what all the Durman Strang is about. You had 4 cases you went in, 3 had to do with campaign violations, and you couldn't put that on the agenda. You couldn't write on the agenda that 3 of these cases are potential cases regarding campaign violations. And then the public would have some idea as to what the hell you were doing. But that's just too much to ask. I don't remember what the first case was, but it was something in the same thing where you could have given a vague description without compromising anyone's rights or anything else. And very frankly, the harder you fight, the more obstinate you look. That's just basically it. And I think that the reason that you come to these meetings now and you see that very few times do the members of the public bother to come is because they know you don't give a damn what they think. You make it very, very obvious by your demeanor, by your comments, by interrupting somebody in the middle of their speech. And somebody shouldn't have to be interrupted in the middle and then have to come back and get their frame of thought. And Ms. Johnson, basically, from talking to her out in the hall, was just so angry that she didn't feel that she could come back in here and express herself in a way that she wanted to do so in a public forum. So your apology is a day late and a dollar short, and it isn't even to the person to whom it should have been given.
The next item on the...
Oh, you have to vote.
Didn't we just vote?
No.
Oh. My apologies. All in favor? Aye. Opposed? Hearing none, the motion passes. The next item on the agenda is discussion and possible action. Discussion and possible action on the minutes. Public comment.
Again, Ray Hartz, Director, San Francisco Open Government. These minutes are a perfect example as to why I fought so hard for the right to include 150-word summaries in the minutes. Using a number of rationalizations, the minutes are pared down to nothing, particularly as it relates to the comments made by the public. If you look at all of these comments in here that you summarized, they're meaningless. They don't really, somebody gets up and talks for 3 minutes and you get one sentence out of it. Shows to me you aren't even damn listening. In fact, these minutes are nothing but a de facto censorship of public participation. If anyone hearing these comments believes I'm off base, I'd simply ask them to come here, speak for 3 minutes, and then read the summary of what you said in the appropriate minutes. I don't think you'll recognize it. See for yourself whether there is anything that you said which is representative in a meaningful fashion. And I'll say it one more time. We are talking about constitutionally protected political free speech. The protection of that free speech extends to its representation in the public record, especially where that public record is being paid for with public funds. This is particularly true when the free speech equates to a petition for redress of grievances. And whether you like it or not, all of the public comments having made last week and this week have the basis in a petition for redress of grievances. We feel that you are handling things inappropriately or in some cases unlawfully, and you denigrate the speakers. You dismiss their comments, and the one thing you never will do is take an action to make any effort whatsoever to change your ways. You're just determined that the public is not going to be involved in this public meeting if you can keep them from. And if the public has something to say, you're not going to even make an attempt to put into the official record what they say. Mainly because you don't like what they say. And you can deny that back and forwards and up and down, but that's the bottom line. You don't like what we have to say about what you do or don't do. And as a result, you pay him to put in a couple short sentences and censor what we are putting in there. And don't say because we get to say it that it's not censorship. Government censorship includes taking what a member of the public has to say and then misrepresenting it in the official record. That's what the Library Commission has been doing for years, and that's why I started fighting for the 150-word summaries, because it is important that these things be on the record, because I am sick and tired of people raising issues at meetings and then a year later when the shit hits the fan, them going, oh, nobody ever said anything. And you can all sit and look down at your desks. Shows the kind of integrity you people have.
Is the comments on the minutes? Is there a motion to approve the minutes from the May meeting? Second.
Second.
All in favor? Aye. Opposed? Hearing none, the motion passes. The next item on the agenda is discussion of the Executive Director's report.
Just a couple of things I want to highlight. I did ask for, and we will receive help from the Controller's Office on some of the audits that are pending. They're going to help us with a dozen audits, and I think that means by the end of this calendar year, we'll be completely caught up on all audits, which will be a first for us in a long time. So I think that's very good news. We have a major filing coming up on July 31st for the filing period of January 1st through June 30th. I would point out the training that the FPPC and the FTB did for us. We are very grateful that they took time to come down here and do an all-day training with our staff. We found it extremely useful. And as you can see, the Deputy Director wants to turn the ED report into a newsletter, but he thought the picture would emphasize the comedy of the situation. We're going to maybe be just a little bit short on our revenue anticipation this year. Because of increased compliance, our revenue stream has been going down. So our revenue target for this upcoming fiscal year is going to be $75,000. Those are my highlights.
Questions for the Executive Director relating to the Executive Director's report? Public comment.
Commissioners, Ray Hartz, Director, San Francisco Open Government. This report is always a generic, one-size-fits-all, check-the-box evolution. Nothing more, nothing less. To make these discussions more meaningful, at least for me, each month I intend to go select one specific item to discuss. Today it's item number 7, on statements of economic interest. For years, City Librarian Luis Herrera accepted thousands of dollars of reportable gifts from the Friends. He did so while ignoring his fiduciary responsibility to provide oversight for the $60 million expended by the Friends between 2000 and 2013. And I will ask, if the public could see the screen, they would see all the commissioners are busy doing busy work because they haven't got the integrity to look me in the eye. He did so while ignoring his fiduciary responsibilities to provide oversight for the millions of dollars raised and expended each year by that group. And year after year, he perjured himself in denying the receipt of those gifts. In a quid pro quo arrangement, he accepted the gifts, lied about accepting them, and looked the other way relating to the finances of the Friends and where all this money was going. He also abused his position as city department head to withhold public records which would uncover this illegal activity, and he did so in violation both of the Brown Act, the California Public Records Act, and the Sunshine Ordinance. Members of the public end up having to do your job. It's all well to sit around and talk about somebody failed to use the right type size on a flyer or other crap like that, which, as far as most of the citizens of San Francisco, I don't think one of them would give it two hoots. But you have a city librarian, a department head of this city, taking a payoff from a group and then letting them expend $60 million raised in the name of the library and then come before the public and represent that he knows where this money went. And the bottom line is, after 2 solid years of public document requests, it took a year to get what we needed to get for the FPPC to find him in violation and find him. And he got a pretty good deal there. He got $5,000 a year worth of trips and hotel stays, etc., and he paid a $200 fine for each of those years. Sign me up for that deal. Give me $5,000 worth of freebies, and if I get caught, I'll pay $200. And if we came to you and asked you to look into something like this, you wouldn't do it. We have to go to Sacramento. In other words, as I said before, we have to do your job because you're too intent on covering the asses of other people. And that's exactly what happened when Mr. St. Croix scheduled my hearing regarding to that referral from the Sunshine Ordinance while I was out of the state. Cover their asses. discuss it as you want. It's the truth. Silence gives consent.
Items for future meetings. Any items that the commissioners would like to propose for future agendas?
Well, without necessarily conceding the merits of some of the arguments that have been made tonight, I do wonder, and I would ask the staff to look into this, as to why we don't, when we have these hearings on probable cause and or stipulation, don't identify what the alleged violations are of what statutory provisions of the election code or whatever code it may be, so that the public would have some awareness that what the subject matter is of the closed hearings.
Yeah, and I agree with that. I mean, if there's some way to at least put something general so that people have some idea, I think that makes absolute sense, and it's something that we should be doing. Along those lines, I, at some point, would like to take up the comments made by those two individuals who appeared to have been given faulty information. At least that's what their allegation is. So the question is, how do we make sure that people who want to run for office are getting the proper information? And is it a good idea? I thought his idea of a checklist, similar to what the election department had, sounded reasonable. I don't know really how easy or not easy it is to do something like that, or if it's even relevant to what we do.
We'll talk about looking at the candidates' guide and see what would be appropriate.
But also, I mean, do you ever have any concerns that if people come in personally, that all staff knows what to tell them in terms of filing dates and all the forms? They all know what they need to tell the candidates, presumably.
Yeah.
So would you say that probably these two individuals, there was some misunderstanding, or do you know what happened in those cases?
I don't know the exact specifics, but the process is a little overwhelming for first-time candidates.
Absolutely, I can understand that.
There are a number of filing requirements, and at any given sort of conversation, somebody could think that they have everything and then they've forgotten something the staff was telling them. I will tell you that for the form that they referenced is due very early, so it's unfortunate, but it's due very early in the process.
Those are both excellent things for the staff to consider, and that we should take up at the appropriate time. Public comment.
And I don't know how much more clear I can be about this. The case you heard in March, referral from the Sunshine Ordinance Task Force, I'm specifically asking you to call that back and have a rehearing. You had a hearing, made no effort to determine why I was not here, although I was the party of interest. And you can shake your head and do all this other crap. The bottom line is, if you went into a hearing and they held the hearing without letting you know, and simply, I'm not talking about simply sending out the notice, oh, we checked the boxes. I was out of the state and did not receive notice until I got back. And if somebody did that to you, are you honestly going to sit there and look at me and say, oh yeah, I wouldn't have any problem with that at all? And the reason I'm saying this is for one particular reason, is during that hearing, Mr. Herrera came in here and lied through his teeth. He said it would take $40,000 for him to allow me to put a slide up on the overhead in their library auditorium. No, it wouldn't. He could do the same thing he does with the Friends and every other group that they approve of, which is they send him a PowerPoint presentation and they include it. Didn't cost him a penny. Wouldn't cost him anything, and it wouldn't be different. In fact, the Sunshine Task Force specifically asked them during the hearing if that's the case. And they said, They don't like what I have to say. And I think you understand that feeling very well. And they don't want to allow me the ability to use the overhead projector like all the groups they like who are there in favor of, because I would say things and put up things that would be very easily discernible. I spent 14 years teaching for the University of Hawaii, so I can get up in front of a group of people and make a point in a very clear and precise manner, and with graphics, I'm killer. And they don't want that up there because they don't want the public to see that. That's viewpoint discrimination, pure and simple. It's a violation of my First Amendment rights because it puts me at a disadvantage as related to other people speaking on issues before the Library Commission. And it was based, again, on Mr. Herrera's lies to the Library Commission, which they thankfully bought, with this argument that he had to spend $40,000 to put a couple slides up on the screen. Now, I don't know about you. I'm ticked off because of the way it was handled and the fact that I was denied due process. Frankly, it was. And I think the issue comes down not to whether you sent notice, but whether I actually received notice, because I was out of the state and can prove it. The second thing is whether you have the integrity to have a hearing and at least ask that the participants or involved parties be part of that hearing.
Is there a motion to adjourn the meeting?
So moved.
Second?
Second.
All in favor?
Aye.
Aye. Meeting is adjourned.